Excellence webinar series, which is sponsored by Black Hills IP and the SLW Institute. Black Hills IP is a U.S.-based service provider offering IP docketing, paralegal, analytics, and annuity services. The SLW Institute is an educational group created by the Schwegman-Lundberg-Wissner firm, which aims to provide insightful and useful information to the IP community. For this webinar series, we have pulled together experts to talk about strategies and best practices for patenting in key foreign countries. The Foreign Excellence webinar series is free. This is the sixth one of several monthly webinars in this series. The schedule and registration information for upcoming webinars is listed on our website. To register for future webinars, go to the tab for Educational Resources on the Black Hills IP website, which is www.blackhillsip.com. The webinar that we are presenting today will cover Taiwan. We have allowed time for questions at the end of the webinar. Questions may be submitted using the question box on the right-hand side of your browser window. You can submit a question at any time during the presentation. The question will be held in a queue until the end of the presentation, and then we'll go through them at that time. The presenters today are myself and Daisy Wang. I'm Ann McCracken, the president of Black Hills IP. I'm a patent attorney with 20 years experience in patent prosecution. I was a partner at the Schwegman firm for 10 years, and I was also a full-time law professor and directed the patent prosecution program at Franklin Pierce Law Center for 5 years. Daisy Wang is with the firm Lee & Lee in Taiwan. Let me read Daisy's bio to you. After she received an LLB from National Taiwan University, Daisy pursued and received her LLM from the University of Illinois. Daisy served with the National Bureau of Standards for more than 2 years and joined Lee & Lee in 1979 for handling patent and IP-related matters. Daisy is experienced in handling patent procurement and strategy consultation, patent dispute resolution, technology licensing, and other related IP services. As of the 1990s, she has handled various leading patent and IP cases for companies like Intel, Philips, ABB, Sony, Celanese, and many others. As of the 2000s, Daisy has started to help clients with their greater China patent and IP matters, including both prosecution and enforcement aspects. Since 1999, Daisy has continuously been nominated by reputable IP professionals organizations via surveys done by various international organizations such as IP Asia, MIP, Who's Who, Chambers and Partners, IAM, American Biographical Institute, Expert Guide, Intercontinental Finance Magazine, Lawyers World Country Award, MIP IP Star Award, Legal Comprehensive Law Award, Acquisition International Magazine, IP Law Experts, Asia IP Experts, Corporate Live Wire, Newton Media, and others. Daisy's firm is also an interesting firm, and I want to comment on it just briefly. Lee & Lee was established 52 years ago as a general practice firm in Taiwan. In 2015, they had their 50th year anniversary, and at that time they were the largest law firm in Taiwan, owing to the foundation that they laid in the beginning. The firm is known for expertise in all legal fields and offers a full range of services. IP is one of the most important practice areas for Lee & Lee since the establishment of the firm. And one of the things that I think is very interesting and unique and a good thing to know about them is that they can also practice in China. Many of their attorneys have passed the bar exam and are patent attorneys in China as well, so they can support clients in both areas. All right, today I'm going to start by discussing various statistics about patenting in Taiwan and looking at some data and trends, and then Daisy will talk about the patent process and share her expertise on how the process works in Taiwan. So first, just as a backdrop, let's look at some market considerations. The countries we're showing on this slide, other than the United States, are the countries that we have highlighted in our webinar series so far. The U.S. has the largest economy in the world, followed by China and then Japan. The size of the economy in Taiwan ranks 22nd worldwide based on GDP. And Taiwan, as you can see, has a very services-based economy. Looking now at patents granted in Taiwan, the next slide shows the top 10 technologies based on patents granted in 2016. The largest technology area is semiconductor devices, and that accounted for 9% of the total patents granted in 2016. That's followed by the next largest category, which is electronic digital data processing, and that accounted for 5% of the total patent grants in Taiwan in 2016. So clearly, looking at those top two and the other ones here on the list, companies in the computer and electronics area are regularly filing in Taiwan. Next, the top patent assignees are shown. Again, this is based on patents granted in 2016. Intel had the most patents granted in 2016 with 854 patents. That was followed by, I believe this is a Japanese company, Semiconductor Energy Lab. They had 772 patents, then followed by Samsung, Tokyo Electron, Apple, LG, Qualcomm, Toshiba, Applied Materials. So again, you can see computer electronics companies are large filers in Taiwan. Now, looking at the number of applications filed per year over a period of years from 2012 to 2016, I want to focus on how many patent applications are being filed by non-residents. So this data comes from WIPO. The term resident in the WIPO data is used to refer to filings made by applicants at their home patent office. So non-resident refers to filings in a foreign patent office. So in other words, when the patent office in Taiwan receives an application from a foreigner, that's what WIPO would call a non-resident filing for the Taiwanese patent office. In this case, the number of non-resident applications filed in Taiwan over the 5-year period from 2012 to 2016 has been lower than the non-resident applications filed in China, Japan, and Korea, but it is higher than the number of non-residents filing in Canada and Mexico. And that number of filings in Taiwan by non-residents has really stayed pretty consistent over the years. There isn't really a trend upward or downward on that. The next slide shows the number of patents granted over that same time period to non-residents. In this case, the number of patents granted in Taiwan to non-residents has increased significantly. You can see that in that blue line. And as I was preparing for this program, I talked this over with Daisy because I thought it was quite interesting to see this significant of an increase. And Daisy explained to me that this is a result of a very intentional effort on the part of the patent office in Taiwan to reduce a backlog that they had. So this increase in patents granted is reflecting the efforts that the patent office has made to get that backlog cleared out. And they even recruited additional patent examiners to work short-term as they were assisting with this effort to get the backlog taken care of. The next slide shows the total number of patents in force in the countries that we've been looking at: China, Japan, Korea, Canada, and Mexico. I didn't have data on Taiwan, but Daisy provided it to me. So the total number of patents in force no, actually, this total number of patents granted. So I don't have patents in force, but I can tell you the total number of patents granted in 2017 across all categories of applicants, residents and non-residents, was 71,871. Unfortunately, I don't have a breakdown of the total in force, but that'll at least give you an idea of the last year, how many patents are granted across all applicants. Then finally, the last thing that I think is interesting to consider when you're thinking about whether or not you or your client should file in Taiwan is the cost, just to not only to acquire the patent, but also to maintain the patent. Again, looking at this relative to the other countries that we've considered in this webinar series, the cost for a patent in Taiwan is a little less than well, actually quite a bit less than China, Japan, or Korea, but more than Canada and Mexico. And that's a combination of the average cost to prosecute the patent being about $8,000 US, and then the average cost, not the average, but the cumulative cost of the annuities over the lifetime of the patent being a little over $10,000. So the lifetime cost of acquiring and maintaining a patent on average in Taiwan, you could figure, is about $18,000. Next, I'm going to turn this over to Daisy to talk about the practice in Taiwan and explain the differences between where things differ between U.S. practice and practice in Taiwan. So Daisy, I'll let you take it from here.
Yes. So may I have the hand, the small hand, so I can manage my PowerPoint? Okay, I saw it. Thank you. Thank you, everyone, and also thank you, for making this arrangement. And well, I think and just share with us some statistics. But I do have one piece of information to share with you. If you look at the USPTO statistics, the patent applications filed from Taiwan applicants actually is quite significant. In 2016, I think Taiwan is the number 4th foreign countries before the USPTO for the patent filing, next to Japan, Korea, Germany. So Taiwan has a very potential research and R&D, research and development resource in various technology area, especially in the information, computer, telecommunication areas, and of course, looking at the new technologies, AI technology. I just read a newspaper report very recently that Google is setting up a very big R&D base for AI technology in Taiwan. Microsoft is also doing very similar thing, so this is something I want to supplement. Next, I cannot move the PowerPoint, and should I have yeah, okay. I also prepare some statistics for the Taiwan filing. This is actually very updated data for the 2016 data, but in the yellow box of this PowerPoint page, you can see there's a so-called top 100 foreign filing companies for their patent filing for year 2017. I won't show you these statistics now, but if anyone is interested in getting that, feel free to contact us. But still, for the so-called top 100 foreign filing companies, I just want to show you the names. Among the so-called Taiwan companies, TSMC is the number 1, followed by Hon Hai. So these are the 2 major domestic companies for Taiwan. And for the foreign patent applicants, it's very surprising. This is the first year the #1 company is not from other countries. It's from China. Alibaba actually is the so-called #1 foreign company, the non-Taiwanese companies in terms of the number of their patent filing. I think this also explains that the Taiwan industry, the Taiwan is a very major area, especially from R&D viewpoints in the telecommunication and also the AI technology area. Alibaba is #1 and followed by Qualcomm, Applied Materials, and Intel. So this is the first thing I want to share with you. And I cannot move to the next page. Okay, thank you. So I will start from some unique features of the Taiwan patent practice. First of all, I need to go back to the earlier page. Okay. Okay. First of all, Taiwan is not a member of the PCT. Taiwan is not a member of Paris Convention either. So this makes the Taiwan patent filing very unique. You have to go through the national filing. The PCT route does not apply in Taiwan. However, for the priority claim, we can still make it. And also a PCT application can be considered as a priority application when filing patent cases in Taiwan. The other thing I want to highlight is in Taiwan, we have 3 kinds of patent: invention, utility model, and design patent. There's one interesting question here that is between Taiwan and China, do we have the so-called reciprocity for priority claim? The quick answer is yes, we do. So this actually was based on a so-called cross-strait IP intellectual property agreement signed by China and Taiwan in 2010s. If companies that have R&D operations in China and they file the first patent applications in China, we can use the China application as a basis to claim priority in Taiwan for the Taiwan filing. Novelty, we do have absolute novelty requirements. It's a worldwide. So basically, any public disclosure anywhere in the world may create a novelty issue. In the past, we have a so-called 6 months grace period based on certain specified public disclosure. But last year, the patent law was amended to extend the 6 months to 12 months. So in other words, if there's any either voluntary or involuntary disclosure of the invention, basically the applicant has a so-called 12 months grace period for filing a patent application without jeopardizing the novelty for the invention because of that particular public disclosure. Of course, the patent publication, laying open publication, is not qualified for getting this 12 months grace period for novelty. We adopt the first to file principle. So in other words, the earlier filing will ensure a so-called priority for being granted the patent if there's another one filing a later application for the same invention. Quality of the Chinese patent transition is extremely important. In Taiwan, this is different from the practice in China. In China, you have to file a patent application based on the Chinese patents, vacation claims, and drawings. So in other words, you have to prepare the Chinese translation before you file the case in China. But in Taiwan, we may use for example, the English patent application or Japanese patent application to file the patent case first, so that we can get the earlier filing date and preserve the priority claim. Within 4 months from the Taiwan filing date, we have to submit the Chinese translation of the patent text so that the original filing date and the priority claim can be maintained. So this is number one regarding the submission of the Chinese translation. So the foreign clients, foreign patent applicants do not have to worry about the coming priority deadline. We can use the original foreign language patent application for filing first. But the question is, when we prepare and submit the Chinese translation, we have to be very careful, because if the Chinese translation involve any substantive change or very, very vital translation error or improper translation from the content of the first file, the foreign language patent specification, the result is the patent applicant may lose the original filing date. That means the filing date will be postponed to the date of submitting the Chinese translation. And also, this change of the filing date may jeopardize the priority claim already made. So this is one one area of why the Chinese translation is so important. And the other one is maybe during the filing stage, this so-called substantive change will never be found out by the patent office, but the same risk may occur during the patent prosecution procedure, or even at a later stage when the patent is in dispute. So this is very important. And in fact, the translation of a patent document is a very, very complicated work. Which I won't give too much details today, but that's very important. Okay. And subject matter. For the subject matter, I think for invention patent application, basically it could be object, could be process, or method. The software-related inventions, like the use of a particular software in a hardware apparatus, or business method inventions, even the computer-readable storage media invention, they are all allowable for patent protection. But the problem is the disclosure in the patent specification has to be sufficient to highlight the hardware, the nature of the invention, and also to show the so-called technical problem, and also the technical measure to work out the problem, plus the so-called technical effects. In the chemical area, either compound invention, composition invention, use invention, secondary use, they are all allowable for patent protection. Of course, the process for making any of these are also allowable for patent protection. So this is the subject matter. I want to talk a little about the utility model patent application. Well, this question was raised to me quite often by the clients from all over the world, mainly because in some countries, they don't have the utility model patents. So they really do not know what the utility model patent means as far as the so-called patent protection is. And also, companies will raise these questions because they are planning for the so-called strategy for getting the patent protection in Taiwan in the most effective way. In the most effective way, that means either they want to save the cost or get more option, to see whether they should go to, for example, invention patent application. So this is basically the background for, companies are always raising the question regarding utility model patent application. But let's take a look. What's the subject matter? As compared with the invention patent application, the major difference is a process or method invention is not the subject matter qualified for utility model patent filing. So in other words, for utility model patent filing, the subject matter should be a very tangible, the creation improvement regarding the structure, the construction, the form of a object. It's like an article or apparatus, and process method inventions is not suitable. And the major difference between invention and the utility model patent could be reflective on different aspects. Number one is from the examination process viewpoint. A utility model patent is only subject to a formality examination. There's no substantive examination involved, which is different from invention case. And the second area, the difference is the different patent term. Utility model is a 10 years protection, invention 20 years. Subject matter differences I already mentioned earlier. So these are the major differences. But since a utility model patent is not going through the substantive examination before it is granted, so according to the patent law, when a utility model patent decides to enforce his patent, utility model patent, he has to go to the patent office to get the so-called utility model evaluation report. This report, in nature, is kind of a so-called search report. So when a search report is applied for, the patent office will do the search. They will cover like a novelty, inventive step, those kind of nature for the searches, and they will show the search results in the report. There's one thing which is very interesting, that is in Taiwan, not only the patent owner can apply for the report, but also any third party can apply for the report. So, this is something which could be, very important for a patent applicant filing utility model patent, because you spend the money, you take the time to get a patent. If a third party put together a lot of prior references to apply for the report, most likely the report will show a very unfavorable result for the utility model patent. So this is a part of the introduction of the utility model patent. We do have a so-called two-tier filing practice in Taiwan. That means the same applicant could file one invention and one utility model patent on the same day for the same invention. And when they file the so-called two application on the same day, he has to make a declaration. This is a two-tier filing. So in the patent office, these two applications will be considered as a set. Of course, for utility model patent, since there's no substantive examination, it will be granted very quickly, maybe 8 months or 10 months. But invention cases, of course, takes longer before final decision is issued. So for the so-called two-tier filing, the applicant could get a utility model patent granted. At the time when the patent office decides to allow the invention case, the patent office will notify the applicant and request the applicant to make a selection between the two, so that there will be no double patenting issue. If the applicant decides to choose the utility model patent continuously, the invention case will not be allowed. If the applicant chooses invention case, he has to give up the utility model patent. But for whatever utility model patent duration year having already passed. During that time period, the owner is still entitled to the utility model patent protection. In other words, the utility model patent protection will be considered terminated only when the invention patent case is granted and published. So this can later the patent applicant to have an earlier patent protection in the marketplace and also longer protection if he get a utility model patent but choose the invention later patent later. So this is a very unique procedure, and some of the high-tech companies are trying to use this approach for different reasons. Number one, get the patent protection earlier. Number two is they are not sure whether they really want to continue the invention application to the end. So they can buy time to consider this. And the third reason is for some companies whose business is major the licensing of technologies, they may, through the two-tier filing approach, they can, have a much more patent in their portfolio, which will be important for their licensing negotiation. Design patent application. I think Taiwan, as far as I know, Taiwan is probably the only one country who use, who is like the U.S. design patent practice, because we also use the substantive examination for design patent cases. So you have to go through the substantive examination before the design patent case is granted. The subject matter could be the shape, pattern, or color, or the combination of a tangible article. Since year 2013, the icon and the GUI designs are allowed for design patent protection. We can see the Patent Office statistics over the past several years. The design patent filing actually increased quite significantly as compared with utility model and design patent. Now I want to go over with some practical information regarding the examination. We just mentioned about that utility model patent is the only one patent which is not subject to substantive examination. But today I want to focus on the invention patent application. Actually, for either invention patent application or design patent application, we have two examination stages before the Patent Office for them to conclude the patent application. The first examination stage and the re-examination stage. According to the law, if a case is rejected at the first examination stage, the applicant could apply for re-examination, and the examiner in charge of the re-examination must be different from the one who rejected the case at the first examination stage. So this is the number one. And for an invention patent application, like most other countries, the patent case will be laid open 18 months from the filing date, but you have to request for a substantive examination so that the invention case can be moved on. Otherwise, the invention patent application will become abandoned. Like the utility model patent evaluation report, the request for examination for an invention case could be filed by the patent applicant or any third party. Of course, if a third party applies for the examination of the patent application, the purpose is very clear. They want to prevent or disturb the allowance of the invention application. Normally, the third party will put together some references and even their arguments regarding why the invention case is not patentable when they file the request, and the Patent Office will consider those information arguments. Patent division is possible as long as the invention case is pending at either examination stage. If the patent invention case is allowed at the first examination stage, a post-allowance patent division is available. But if the case is allowed at the re-examination stage, you could only do the patent division before the re-examination decision is issued. Post-allowance patent division is not allowed under that situation. Amendment is a very interesting topic. I'm sure that some of you are very familiar with the China practice. China has a very strict timing requirements for making amendment of an invention patent case. Taiwan as well, but probably a little better than China. In the US, you can apply for the amendment at any time with the USPTO. But for example, for Taiwan, the invention case, you can apply for the amendment at any time before the first office action is issued. After that, you could only apply for the amendment when you file a response to an outstanding office action. So this is the so-called timing requirements. Otherwise, the other requirements is pretty much the same as in other countries. Any amendment could not change the substance of the original disclosure of the patent application. After a patent is granted, the patent applicant, patent owner can also apply for amendment. However, there's only certain grants. Based on any of that, you could apply for the amendment, post-grant amendment. For example, if you want to reduce the claim scope, if you want to clarify the unclear disclosure, or correct the very obviously erroneous disclosure, or if you want to correct the translation error in the previous file, the Chinese translation of the patent. So those are the grounds for doing the so-called post-grant amendment. But if you want to add new claim or enlarge the claim scope in this stage, it's not allowed. Okay. So this is maybe the most important features for during the patent prosecution procedure. I want to talk about a little bit about the so-called PPH and also the expedited patent examination practice. This so-called expedited examination mechanism has been utilized by many foreign companies very recently. I mean, for the past several years. Normally, if you without the PPH request, the patent office will just take the normal examination track to handle the case. But if you apply for a PPH request, if that's a qualified request, you may get a response from the patent office within like 2-3 months, very fast, and the allowance rate is very high, more than 90%, 92, 95. 93 around. Okay, of course for PPH there's some limitations. PPH has to be filed before the first office action is issued for the Taiwan case. Also, you have to base on the allowance of the priority application, not other foreign corresponding case. The claim should be the same. And the other thing is for Taiwan Patent Office, we now have the PPH cooperation with several countries, not every single country, US, Japan, Korea, Poland, Canada, and Spain. So these are the countries. In Taiwan, there's another fast examination track, which is much more flexible than PPH. It's called AEP, Accelerated Examination Practice. Based on any of the 4 grants, you could apply for the AEP if any corresponding foreign case has been allowed. This is different from the PPH. PPH is only limited to the priority application. Or if you have a case before USPTO, JPO, EPO, even though the case has not been allowed, but the prosecution history is helpful. Or if you have a commercial need, or if the invention is a green technology. So based on any of these four, you could apply for the AEP. And like I said, AEP could be filed anytime. Even after the office action has already been issued for the Taiwan case, you could still file the AEP. So in practice, if a client comes to us too late for filing a PPH request, we normally go to the AEP. Okay, in this chart, I show you some comparison between the so-called time needed for receiving the office action, the time for concluding examination among the three examination track, the normal track, the PPH, and the AEP. So you could see it's quite different. And there's a one thing which is not shown in the in the chart, but I think I mentioned in the bottom, in the red wording, that is the normal track. Maybe the allowance rate is like close to 70%, but if you go to the PPH AEP, that will be more than 90%. So for this reason, many companies, they start to use PPH and AEP very aggressively so that they can get the patent earlier and also reduce the total cost globally. You may ask one question: since PPH and AEP is available under the presumption, the claims of the foreign case and the Taiwan case is the same. If I still have other claims which is not included in the foreign allowed claims, so what should I do? When you apply for the PPH, you could do the patent division, so that for additional claims, which is not same as the foreign allowed claims, you could still continue with the additional, the so-called patent additional case. Okay, it's moving to almost the end of my presentation. Strategic factors. This is an additional, in addition to what I already explained. Quality of the patent translation. This is very important, as I mentioned earlier. And the other one is you may consider how to combine the patent filing for the Greater China into one big region for cost efficiency and the patent quality purposes. For example, we have many clients, they ask us to manage their patent filing prosecution for the Greater China area. So we have the same team working on the invention in the same family or corresponding inventions for both Taiwan and China. And we could share a lot of resource generated from the patent prosecution. We could also reduce a lot of repeated work. And the more important is consistency for the arguments. So this is two additional comments I would like to share with you. It's also experience. Before I end of this presentation, I just want to give you some highlights about the major feature about how to enforce a patent in Taiwan. As compared with US, I think in the legal system, we don't have a discovery procedure like you have in US. So in other words, before we file a lawsuit with the court for patent infringement case, we have to do a lot of homework, like patent infringement analysis, like hiring the private investigation company to collect the evidence, to do the patent validity assessment just in case the infringer will challenge patentability and so on. So, so all this has to be done before the litigation is filed. We have an IP code which was set up in year 2008. The IP code is handling all kinds of IP litigations, including all the civil IP suits for patent, trademark, copyright, trade secret, unfair competition, IC layout protection, and also the IP code handles all the administrative suit for all kinds of IP. For example, if we get a final decision from the patent office for our patent application, we do not like the decision, we could apply for, file the administrative suit with the IP code after we file the administrative appeal, which is also dismissed. So this is the IP code. And in China, in Taiwan, patent infringement is subject to civil liabilities, which the remedy mainly include damage award and also preliminary permanent injunction order. I'm sorry, this is a typo. Permanent injunction order, and the statute limitation is 2 years from the knowledge of the infringer or infringement, or 10 years from the so-called infringement act, whichever is earlier. Provisional attachment order, preliminary injunction order are all available in our legal system. We don't have a discovery procedure. We do the pre-litigation investigation to support the evidence producing obligations. But during the court proceeding, or even before we file the lawsuit, we could apply for the evidence preservation order from the court. But we have to clearly identify what evidence and why the evidence is relevant to the patent infringement claim, and also we have to show to the court that if the court does not seize the evidence, there's a high possibility that such evidence could be lost or destroyed. So this is the evidence preservation order. Trade secret protection is always involved in the patent litigation. We do have the so-called protective order available in our IP infringement practice. So in other words, the IP code could issue the protective order if there is the so-called trade secret involved. Okay, patent validity challenge. Basically, the validity issue could be handled by the patent office if a third party file a so-called invalidation action with the patent office. But the court hearing the patent infringement suit also has the authority to deal with the patent validity challenge raised by the defendant at the court. So this is a very quick overview about how to enforce a patent, and I want to end my presentation here and see whether there's any question.
Thank you, Daisy. Let me go to the next slide. All right, so if you have questions, you can submit them in the question box on the right-hand side of your browser. If you're interested in learning more about Black Hills IP, we have Jim Brophy's contact information. If you'd like to learn more about the SLW Institute, please contact Brian Ness. His information's on the slide. And certainly, if you have questions or need assistance in Taiwan or China, I'm sure Daisy would be happy to talk with you, and her email address was on the contact slide, the presenter slide at the beginning of this program. We'll be making these slides available on our website along with an audio recording of these slides. Give us a couple of days and we'll have those posted on the blackhillsip.com website under the Educational Resources tab and in the Foreign Excellence portion of that tab. So, Daisy, there is a question here about translation. And I'm not sure if you'll be able to provide much information on this. I don't know if you do translations internal at your firm or if you use outside services. But the question is, how much does it typically cost for a quality translation? Let's say, for example, the patent application is in English and it's 30 pages. Those 30 pages are double spaced. Do you have any idea on what a average translation cost might be for a patent like that?
This is a question, which I probably cannot answer precisely because we do have a so-called translation fee. But let me try my best. 30 pages, if each page is 600 English words, this is a presumption. So it will be like 18,000 words, right? And so let me roughly, this is a very roughly calculate, but I want to just give me 1 minute. I can.
Sure.
It's probably like 20, between 2,000 to maybe 2,500 US dollar or less. This is a very rough estimate, but I'm more than willing to give you the precise number tomorrow. When I go back to office, I get the information you can share with whoever raising the question.
Sure. We'll connect them with you so that you can reach out to them.
Yeah.
Okay.
There's one comment I want to mention is talking about the translation. Many people do not know the Chinese language in Taiwan is totally different the Chinese language in China. So some clients will raise the question that can I use the Taiwan translation for Taiwan for filing in China? The answer is no. And also there's some people who will raise another question that is, can we use a computer to convert the first Chinese language in Chinese translation into the second one? The answer is again no. That's because the language, the characters, the terminologies, the writing side between the two Chinese languages are totally different. However, many companies they start to think about what's the best way to make the best use of the resource generated between the two translation process, one for Taiwan, one for China, so that they can reduce some of the work and then reduce the cost. So this is actually what we are doing for the translation for the so-called Greater China patent service clients. We handle two translations still independently, but we don't duplicate the efforts, and we share the for example the terminology database and so on. And the end result is for the first translation you may pay the full fee, but for the second translation, either Taiwan or China, you could save like 40% of the translation fee.
Wow.
So I will send you the information tomorrow,
okay.
And please feel free to share with the audience raising this question.
Sure. Thank you. And that's a great tip on the translations. And another thing I assume that also helps to keep your translation costs down is not to do them at the last minute, because that fee that you quoted, the estimated $2,500, I'm sure would not include any rush fees or anything like that. And the translations can get very, very expensive if they're done in very short timelines and rush fees apply. Correct, Daisy?
Yes, exactly. And also, I want to also share with you that when we do the patent translation, we have done translation for more than 52 years. even for the China translation, we already have like 15, 16 years experience. But when we do the translation from either English or Japanese into the either one Chinese languages, we also found out that there's some errors or even the illogical or inconsistency statement in the original foreign language version. So this will make the translation very difficult unless you clarify that with the client. So that's why when we do the translation, we also spot the issues and the errors in the original foreign language pattern specification, and we get back to a client to discuss about what the issue and what the correction should be before we finalize the Chinese translation. This is extremely important. Otherwise, based on our years' experience, sometimes the errors or the inconsistencies just make you not possible to do a translation in Chinese.
And that's a great service. And again, though, in order to be able to do that for the client, there needs to be enough time in advance to allow for that process, right? So that's very important. All right, we're at the end of our time, so I'm going to just move on to the last slide, which is our next program. The next webinar will focus on Malaysia. It will be presented on Thursday, April 26th at 1 p.m. Central. Daisy, thank you very much for taking the time to present, and I know this is overnight for you, so again, thank you very much for doing that today. Thank you to our audience for participating.
Yeah, my pleasure. Thank you.
Well, again, I appreciate it, and I learned a lot. I did not know about the accelerated examination program in Taiwan, so that was very useful. I'm glad you made us all aware of that. Anyway, thank you, Daisy, and thank you to our audience. We hope that the audience will join us for the next program on Malaysia and other future webinars in this series. Thank you, everyone. Have a good afternoon.
Thank you. Bye-bye.
Bye.